Hi, it's my pleasure to welcome you today. My name is Nathan Chapman. I'm the Executive Director of the Stanford Constitutional Law Center. And we're in for a treat today. Josh Blackman, professor at South Texas College of Law in Houston, is going to tell us a little bit about his forthcoming book, which is Unprecedented Constitutional Challenge to Obamacare. It's coming out in September, and you follow the case closely, I think, from start to finish. And really looking forward to hearing what you have to tell us about it. And there's going to be plenty of time for questions and answers afterwards, so hopefully we'll be getting a really good discussion going. Okay. Thanks, Joe.
All right. Hi, everybody. How's everyone doing? Good? All right. Thank you to Nathan and Judge McConnell for hosting me. It's a real treat. You are getting the dry run of this. You were in fact the first people to see the cover of the book. And I spent long and hard trying to figure out the perfect image to encapsulate this case. And once I saw this picture, I said, this is it. This case was unprecedented in every respect. It was unprecedented that all three branches of government clashed in this constitutional challenge. It was unprecedented in its popular constitutionalist forces of the Tea Party and other groups they were able to take a constitutional argument and bring it to the Supreme Court. The politics of this case were unprecedented as never before had a president been faced with choices of how to litigate a case and how that would impact the presidential election. This case was unprecedented in every single respect. So first we begin. This case began with the president. When he was elected in 2009, he made his first term to be about health care. This was his mandate, no pun intended. This is what he wanted to do. But the problem was, Congress opposed it. This was not particularly popular. In fact, never before had a law been passed of such significance on such a party line vote. If you go back and look at Social Security, Medicaid, Medicare, ADA, Civil Rights Act, these were all laws passed with 100 vote majorities in the House and in significant votes in the Senate. This was passed on a straight party line vote. But more importantly, this was a case about the Supreme Court. And at least not since the New Deal, and perhaps more so today, has the court been involved in a more politicized, important case. And ultimately, this case is about the Constitution. This was one of the first times in maybe 100 years where the Constitution has been such a relevant force in deciding a political dispute. And I attribute this to the fact of how politicized this decision became. That when all else fails, people revert back to the Constitution. But let's start with the law. Healthcare is expensive. This should surprise no one in this room. It's a very expensive proposition. And over our country's history, there's always been a challenge of how to make healthcare affordable. Some of you might remember this picture, and this picture. Who remembers this? Yes. So in the early 1990s, First Lady Clinton was on a special task force to try and lower healthcare costs. She basically put together a plan that was more or less a single-payer healthcare system. She got in a lot of trouble for doing this behind closed doors, but was put forward. Now, who here remembers this picture? Harry and Louise. Remember this? In the early 90s, there was a strong movement to oppose Clinton's healthcare plan called the Harry and Louise ads. These were commercials of a Midwestern, ma and pa, sitting around the kitchen table worrying about healthcare costs. And we don't want this. We don't want the government making decisions about healthcare. And this was instrumental in killing it. So in 93 and 94, Clinton's healthcare plan was killed. And in part, this led to the Republicans taking the House in 1994. But the problem was, the cost of healthcare remained expensive. This did nothing to address healthcare. And it kind of dwindled and fluttered in the wind for the next 2 decades until this happened. This is when President Obama became president. Or maybe it was when this happened, when he actually took the oath for real. Remember, the first time he did it, the oath didn't take. He had a kind of flub with the Chief Justice. But the second go around, he became president. And when he became president, he made his priority, his #1 thing for his first term in office was to reform healthcare. This is what he wanted. This was his, what he kept calling his legacy. When all the opposition was there, people were telling him, you shouldn't be doing this, he kept saying, this is my legacy. So it became known as the Patient Protection and Affordable Care Act of 2010. You know it now as Obamacare. Now, some of you might not like that term, but that's the term Obama himself likes. He says, I want historians to call this Obamacare. This is my legacy. I want to be called as such. Frankly, I have no problem with that because I think it will be an unmitigated failure, but you know, let that be his legacy. But the ACA ran into this big problem called the Constitution. Now, you're all law students, many of you are. If I would have asked you in 2009, is there anything in the Constitution stopping the federal government from mandating health insurance? The answer would be no. It's commerce, it's interstate commerce. This is clearly, Reyes Lopez, this is fine. But something changed from 2009 to 2012. We didn't have an amendment to the Constitution. There was no new notes from James Madison talking about what mandates were unconstitutional. What changed is the people. And this is a dynamic we call popular constitutionalism, the notion that the people can actually impact constitutional meaning. We actually had this movement spring up in 2009 in large response to the president's overreaching of federal power, saying that we do not want this, that the federal government has grown too much, that there's something about Obamacare that has been never been done before, and it makes us feel funny. We don't want this anymore. The Tea Party kind of sprung up out of nowhere, rallying around the Constitution. And they give rallies across the country, at Congress, and perhaps most importantly, as the ACA was about to clear the House, you had a massive Tea Party protest with thousands and thousands of people saying, we do not want this, stop this, kill the bill, this is unconstitutional. We have all aspects of our republic clashing in this one law, this tinderbox of unconstitutionalism that began and ended right here. So just to go back a little history, in the 2009 election, Democrats swept. They had a filibuster-proof majority lead in the Senate. They had a huge lead in the House. The president could pass any law he wants by fiat. He didn't need to buy a single Republican. Many of his advisors said, you can't do this. You need to get some Republican buy-in, or maybe we should wait till the economy settles down, or we should worry about TARP and these other things. But he was intent on doing this now. In fact, Joe Biden, of all people, said we need 15% Republicans to buy this. Obama said, no, what? We're going to do this. So there was massive opposition from Republicans. They didn't want this. They killed the public option. They killed various other elements of it. But the president pushed forward. He did not want to defeat. In the Senate, they basically wrote this bill behind closed doors. They didn't have the actual bill to consider until that maybe a week or two before the vote. And they had very little debate. And among the debate, there was only one significant portion about the law's unconstitutionality. On Christmas Eve, this was the first time Congress had met on a Christmas Eve in, I think, 75 years to vote. On Christmas Eve, there was a constitutional point of order made, saying that this law is unconstitutional. This was made on the night before the law was voted on. This was the only reference, really, to the Constitution in the entire debate, other than a few other remarks by Orrin Hatch and others. But by the most part, the arguments against the ACA were policy-based. They said we should not have this aggrandizement of federal power. So now we have the ACA. Who can guess how many pages it is? Numbers. Anyone? Bueller.
1,800.
Keep going. Higher.
10,000.
Lower. All right, 2,700 pages. This was the bill passed. It was 2,700 pages. And putting aside all the jokes of whether anyone actually had to read it, there was one very important part. Who remembers here the Cornhusker kickback? Does that ring a bell for anyone? In order to basically buy the entire Democratic caucus, the president and then the Senate gave a special kickback to Nebraska, Senator Ben Nelson, saying, listen, if you vote for this, we will give Nebraska more Medicaid funding. This was a direct kickback to Nebraska, no one else got it. The reason why this was important was that was the key vote to break the filibuster. Once Ben Nelson was in line, it was smooth sailing. And on Christmas Eve, on a straight party line vote, not a single Republican voting for it, every Democrat voting for it, the law passed. But there was one thing which the president didn't anticipate. It's this guy, Senator Ted Kennedy. In August, a few months earlier, Kennedy had passed away. His seat was now in flux. No one could have possibly conceived that a Senate seat that was owned by Ted Kennedy in Massachusetts could go to Republican. No one could have conceived of that. So the bill they passed on that Christmas Eve was not meant to be the final bill. There's certain errors in that bill that will come back to haunt the Democrats very soon. But that was not meant to be the final bill. And then this happened. Scott Brown. Once Scott Brown won the election in Massachusetts, the Republicans had a 41st vote. In fact, Scott Brown campaigned on being the 41st vote. They can now stop the bill. So the Democrats had a conundrum. They had passed this incomplete version of the bill in December. They couldn't pass another one because they didn't be filibustered, so they had to send an incomplete bill on to the House. The problem was the House didn't want that bill. So Speaker Pelosi had a very difficult task. She had to find a way to pass the Senate bill with making changes without sending it back to the Senate. Because once you send the bill back to the Senate for a vote, the Republicans would have killed it. So Pelosi did something very smart. She did something called the reconciliation process. And what this means is usually when you have a bill in one house and a bill in the other, You can maybe, kind of modify slight change without having to vote for everything. So she tried to reconcile the Senate bill, but instead of actually reconciling, what she did was she crossed out all 2,700 pages and added 2,700 new pages. She rewrote the bill in the House. This was the entire demon pass, if you remember that thing, which never actually happened. So Boehner wanted to stop it, but he didn't have the votes. The clash between the Democrats and the Republicans in the House was nothing, because you couldn't have kind of a conflict. Obligatory picture of Snooki, because there was a tanning tax in the law. So Pelosi said, you know what, we're going to pass this on a straight party line vote. By getting the votes of Bart Stupak, the prominent pro-life Democrat, she was able to push this through the House, and it voted. And I love this cartoon. We're amending a law that doesn't exist by passing a bill without voting on it. This accurately characterizes the types of thoughts they had. For the Democrats at the time, this was, we need to pass it now or never. But there was a certain hubris to this, which is tragic in hindsight. Because by passing a law, such opposition was doomed to fail from the start. There was no way to get any buy-in. The reason why this has been in courts for years and will never be accepted, that people still want to repeal it. So it went to the House, Pelosi was able to twist some arms, and it passed. And just take a look at this vote. 219 yay, 210 nay. 9-vote difference. Never before such a massive piece of legislation passed in such a party line vote. Go back and check Social Security, Medicaid, Medicare, ADA, Civil Rights Act. I did the math. President Johnson got more former segregationists to vote for the Civil Rights Act than Obama got Republicans to vote for the ACA. It's striking how he was not willing or able or cared about getting a single vote of the opposite party. And I think that spells a lot of the doom that has come out of the ACA since. So, past the House, on to the White House we go. The President had this beautiful signing ceremony with all the people there. If you look here, that he has 23 commemorative pens. He actually signs a little bit of his name each time, just to use 23 pens to sign it. Gives away his souvenirs. And you think, you know what? This is law. We're done. I won. This is my legacy. This is March 23rd, 2010. The fate of this bill will not be decided for another 2 years. So we go forward. The problem, though, is the Constitution. Was this constitutional? And of course, we have two main precedents, which you are all aware of. So the first one, Wicker v. Filburn. This is actually Farmer Filburn, who was a farmer in Ohio, and this is Secretary of Agriculture, Clark Wicker. This was a case that said, even if you're growing wheat on your own farm to feed your own chickens and pigs and family, it is still interstate commerce. Even if it never leaves the farm, it's still interstate commerce. From this, the court said, anything that has some sort of a substantial effect in interstate commerce can be regulated by Congress. No big deal. So how has the commerce clause evolved over the last 65 years? We have another case. This is actually Angel Ray. She lives not too far from here in California. This is a case where she grew marijuana on her own farm. It was purely for her own consumption. Congress said, even though you're growing marijuana on your own farm for your own consumption, Congress can regulate it. This is actually a picture of Raish when she's on her, if you guys know what that is, the vaporizer. I often ask what college students do you know what that is. Of course, the lawyer for Angel Raish was this guy, Randy Barnett, who years later would become the intellectual architect for this case. In fact, he wrote the foreword to my book, so full disclosure. Raish lost her case, and she had this tragic photo of what it means when you lose a commerce clause case. Let's move forward. So, we have a precedent saying, if you grow wheat on your farm, Congress can regulate it. We have a precedent saying that if you grow marijuana on your property, Congress can regulate it. Okay? What about broccoli? The entire idea of the individual mandate was that we need to force people to buy health insurance. Why? Well, if you're young and healthy, you don't need health insurance. Under the Affordable Care Act, insurance companies can no longer discriminate based on price. So if you have what's called a pre-existing condition, if you have some sort of thing that makes your insurance more expensive, they can no longer charge you anything else. So what's a young, healthy person to do? Don't buy insurance. The second you need it, you go buy it. Even if you're in the ambulance on your way to the hospital, you get your iPhone, you order some insurance, you're good. Congress wanted to stop that. Congress said we do not want people shifting these costs and waiting until the last minute. So what we're going to do, we're going to force you to buy health insurance. Now, they can't literally force you to buy it at gunpoint. What they do is they charge you a penalty if they don't. If you don't buy health insurance, you have to pay a penalty. That's how the Affordable Care Act worked. To make sure everyone buys insurance when they need it, they make you pay a penalty if you don't buy insurance. Okay. That happened in Massachusetts. Most famously, Governor Romney had it in his own state. But that raises the question. If Congress can make you buy your own insurance because it helps fix the national healthcare market, what else can they make you buy? Can they make you buy a GM vehicle to prop up General Motors? Can they make you buy a gym membership? Or, the lingering issue of this case, can they make you buy broccoli? My alternate cover of the book was actually a piece of broccoli, but I dropped it because it got too esoteric. But this became the image. I love this commercial with Stu, Family Guy, but no one likes broccoli. In fact, President Bush 41 famously said, you know what, I'm president now, leader of the free world, no more broccoli on Air Force One. He actually banned broccoli on the airplane. But we have this issue. Can they make you broccoli? Can they make you buy a GM vehicle? These were issues that didn't really come about early on in the case. In fact, I was actually present when this challenge first began. So it's a 2009 Federal Society Lawyers Convention in Washington, D.C. I was there when Randy Barnett and Tal Graziano, a couple of people actually think, how do we challenge this law? How do we make this up? And that's where the entire challenge was born, right in Washington. And I was, by whatever fortuity, I was staying right there. But it was those constitutional arguments that developed back in 2009 that led us to here. So let's go back to the president. You can actually see here the signature of the president is kind of very jagged, especially the O. That's because he uses 23 different pens. So the law was signed March 23rd, 2010. Minutes after the case was signed, we were off to the races. Minutes. Lawsuits were filed within 17 minutes after the law was signed into law. The ink hadn't even dried yet. The suits were filed in Florida, Virginia, Ohio, Michigan, Washington, D.C., all over the country. All these people were challenging, is this law constitutional? Can the government make you buy insurance? One of the first most prominent suits was filed in Virginia by Attorney General Ken Cuccinelli, who was somebody with a Tea Party darling. Cuccinelli broke up from all the other states and filed his own law, which was based on a specious view of standing, where Virginia passed this law saying that the Attorney General can sue the federal government. It was a form of nullification. It was kind of stupid. Yet, at the district court in Richmond, he won, and the president was not happy. This was the first time the court had ruled in favor of an Obamacare challenger, and this was a really big deal. And to compound this was very unpopular. The law had not received popularity. There's a reason why 49% of Congress opposed this law, because the people opposed it. This is not how you start off a law that's supposed to be loved. You have to gain buy-in, you have to gain support. The president will learn this lesson in the years to come, I fear. The big event, though, was in Florida. This is Judge Roger Vinson. In Florida, initially about 13 states, but eventually 26 states of the Union opposed this law. Think about that. Half of the states in our country opposed an act of Congress. Not since perhaps a civil war has this ever happened. It's actually quite unprecedented. I think there were many states in the Confederacy. But this law was just so widely opposed. And the litigation in Florida was the main event. Judge Vinson went one step beyond the judge of Virginia. He said that the entire Affordable Care Act is unconstitutional, root and branch. We can't cut out this mandate. He struck down the entire thing. After this happened, the president was not happy, because now we have a viable case. We say the case is legged. It was on to the courts of appeals, and that there will be several main challenges. So at the courts of appeals, there were a couple of new faces. One is Neil Katyal, the other was Paul Clement. Paul Clement was previously George Bush's Solicitor General. Katyal had argued the detainee cases, the Hamdan cases. Both brilliant advocates, and they will be facing off in several courts throughout the country. So one of the first cases they had was in the Sixth Circuit Court of Appeals. I clerked there, but after the case was argued. And the Sixth Circuit had an interesting panel. One point to focus on, because a lot of you are lawsuits, this is Judge Jeffrey Sutton, who's a judge in the Sixth Circuit. He's a prominent conservative appointed by George W. Bush. He was on a panel with another Republican-appointed judge and a Democratic judge, a Carter appointee, Boyce Martin. It was widely seen that he would be the test of saying if a conservative judge like Sutton can strike down this law, maybe a judge like John Roberts could also strike down this law. Sutton avoided the issue. He had this kind of convoluted opinion based on standing that no one had saying to challenge this law because it might apply to some people and not others. It was a facial challenge issue. It's a complicated thing, but Sutton found a way to uphold it. This was very significant because now you had a prominent conservative judge upholding this law. This was significant because the case had become very politicized. This notion that this case would be a 5-4 split, Republican judges voting one way, Democrat judges voting another way, and that was considered a very bad thing. So the president must have been very happy after this. But he wasn't happy after this one. This was the 11th Circuit Court of Appeals in Atlanta. This was the biggie. This was the appeal from Florida. And you actually had two judges, Judges Hull and Judge Dubina, one Republican, one Democrat, who wrote a joint opinion striking down the mandate, finding it was unconstitutional. This was a big deal. I remember this happening the day after my birthday. But this was a humongous case that sent ripples, because now we have a circuit split. We have one court in the 6th Circuit saying it's constitutional. We have another court in the 11th Circuit saying it's unconstitutional. Never before had this happen like this, where so quickly a constitutional argument that few people took seriously in the span of a year and a half now created a circuit split. This had never happened before. This was actually unprecedented. So the court struck it down, got rid of it. The president was very not happy with this one, I can imagine. We had more cases, this time in the 4th Circuit. The court there upheld it, but there's some weird tax argument that no one really put out afterwards. The president was happy. Before the DC Circuit, though, we had a change of faces. This is the Solicitor General, Donald Verrilli. And he came into power in the SU's office right before it was argued in the DC Circuit. Katyal is out. What's significant, though, about this opinion was because one of the judges in the panel. You had Lawrence Silberman, who was a Reagan appointee, considered a Supreme Court nominee. You had Brett Kavanaugh, who was George Bush's White House counsel, brilliant guy. They both voted to uphold the mandate. Silberman did it on Commerce Clause grounds, saying, you know what, this is a novel law, it's kind of unprecedented, but there's nothing telling us not to do it. Kavanaugh had this really complex, esoteric tax code opinion, saying if you read the tax code, this can't be right. I'm not getting into the details of his opinion, because no one even knew it was coming. He had this obscure provision of the tax code, and I think Judge Silberman asked the DOJ lawyer, have you ever read this provision, counselor? He's like, no, Your Honor. So his opinion came totally out of left field, or it's right field, but it was a very creative approach. But there was one sentence in Kavanaugh's opinion that was key. He made an offhand remark saying, you know what? If you deleted a single phrase in the entire Affordable Care Act, so it's this 2,700-page bill, if you delete one phrase that you have to buy health insurance, the law becomes a tax on not having health insurance. Everything that we've been litigating for 2 years was about this mandate to buy health insurance. He said if you just take out that one phrase, you ignore that one clause, the mandate part, the law becomes constitutional. And this thought stuck with the Solicitor General. He read this and thought, oh man, that's a really good point. If we just read the statute slightly differently, it's saved. And that is what John Roberts did. That one sentence from Kavanaugh's opinion is what triggered in the government the idea that this is how we save the law. So the president was happy after the DC Circuit, but we knew the court would have to take it. I think maybe a week after the DC Circuit decided the case, on to the Supreme Court. And the justices took it. And this would be a case where the president and the justices would have to clash in this very public setting, which is not what John Roberts would want. Roberts wants the court and the people to be happy together. But this hasn't always been the case, with one justice in particular. So who remembers this picture? This was at the 2010 State of the Union address. President Obama was talking about the Citizens United case, and he said this reversed 100 years of law. Justice Alito said, not true. He mouthed it. This created a huge stink, because usually the justices are supposed to just sit there at the State of the Union and just be quiet and not say a word. He said, not true. So the Chief Justice has a very broad view of the court's institution. He doesn't like when the courts are involved in politics. He doesn't want that. To Roberts, this is the wrong thing to happen. He was very much aware of how this would be perceived. So let's move forward. The case was argued in March 2012, just roughly a year ago. As you all probably know, there's no cameras in the court, so the only way to get in is to wait outside in a tent. I've done this before, not with a tent, but just on a chair. And the one thing they don't tell you is that every morning at 3 a.m. there are sprinklers that wake you up at the court. It's very cold. I stayed there in March of 2012, it was 40 degrees, it was freezing outside. And you get a rude awakening. On argument day, it was a circus outside. There was all the festivities and the Tea Party protests. You know, these people kind of trying to gather more attention. But then we go inside the court where it's much more quiet. quiet so much that no one outside can hear it. Of course, that there are no cameras allowed. So we were forced to watch it like this on C-SPAN after the fact. So the arguments in the court were stretched over 3 days. The first day, there was an argument that's something called the Anti-Injunction Act. Okay? Usually, if there's a tax assessed and you don't agree with it, the way you challenge it is by paying the tax and seeking a refund. That's generally how you challenge taxes. You can't say, oh, I'm not going to pay this tax. You have to pay it and challenge a refund. The problem is that the Affordable Care Act was not to go into effect until 2014. No one had been assessed this tax yet. The only way to challenge this law was to say that it wasn't a tax. Say it again. If it was a tax, you can't challenge it until 2014. If you can challenge it in 2012, that means it's not a tax. The Obama administration took the position that for purposes of the Anti-Injunction Act, that the mandate is not a tax. Everyone got that? That was day one. The reason why they did that was because they didn't want to keep this case until 2014. Perhaps at that point, Mitt Romney would just decide not to enforce the law. Or perhaps Congress would have repealed it. Obama wanted this decided now. This is where the politics meets the road. But there was a problem with this argument. By saying it's not a tax for purposes of the Anti-Injunction Act, they have now taken away one of the constitutional bases of the mandate. You know, I talked about the Commerce Clause, but Congress also has broad power to enact laws with taxing power. There's a very famous story. Secretary of Labor Francis Perkins was once having tea with Justice Stone, and they were saying, no, Justice, we want to pass the Social Security Act, but we're afraid about the Commerce Clause. And Justice Stone goes, my dear, the taxing power is all you need. And it's legendary, because the taxing power is so broad. So then they had this weird choice. What made it more complicated, though, is that when the ACA was being enacted, President Obama said over and over again, this is not a tax. This is not a tax. He kept saying that over and over again. I am not raising taxes. So there was the politics there. The president passed this law by saying, I will not raise taxes. But now they don't have to argue it is. Indeed, when the case was first being litigated, the White House didn't even want the government to raise a taxing power argument, so afraid of the politics. Neil Cocktail actually wrote a letter to the White House saying, please, we need to raise this taxing power argument. If we don't, we're going to lose. So they raised a taxing power argument. But at the Supreme Court, Verrilli had a very odd argument to make. On the one hand, it's not a tax for purposes of the Anti-Injunction Act. Hear it now. At the same time, it is a tax for purposes of the constitutional power. Let me say that again. It's not a tax for purposes of the statute, but it is a tax for purposes of the Constitution. If you're confused, it's okay. This is not meant to be easy to understand. Never before had this ever happened where they had to pass a law under, different meanings of tax. This was very novel ground. But Verrilli knew he had to make this argument. In fact, it was difficult for him to make it because many in the Treasury Department did not want to give away this power. By saying that this mandate was not a tax, they were setting a precedent to allow other laws to be challenged before they were enforced. The Treasury Department did not want this. He had to actually fight this point in the government. He won. But he didn't just say it's a tax. The problem with calling this law a tax is because it's not called that in the statute. It's called a penalty. Yes, it amends the Internal Revenue Code and all this other stuff, but if you actually look at how it was enacted, it was not meant to be a tax. No one thought it was. And to the extent that people in legislative history said it was a tax, they were just saying everything they thought of. This was meant to be a penalty. The president said it over and over again. So rather than arguing that it actually was a tax, Verrilli had a very unique argument. He said to the court, the best way to read the statute to avoid the constitutional issue is to construe it as a tax. There's a very subtle difference. Below they said, Your Honor, this is a tax. And then the court said, no, it's not. It's called a penalty. Done. What Verrilli said was, we need to construe this as a tax. As a Supreme Court, as another branch of our government, you need to be responsible in how you construe this law. I spoke with many people inside the government. They knew from the beginning that John Roberts was the fifth vote, not the sixth. They knew Roberts was the key vote to get. And they knew that if they phrase their arguments in terms of this political process and the separation of powers and respect for the Congress, to John Roberts. This is how you're going to win the case. This was really stroke of genius. He got a lot of bad flack, but he called this case very accurately. He argued at the same time that the law is not a tax for purposes of the Anti-Injunction Act, so you can hear it today, but that it was a tax for the Constitution. By tight walking that rope, he was able to split the difference. Yeah, indeed, Verrilli's biggest opponent in the oral argument was actually this, a glass of water. For those of you who remember, he actually choked when he began. The Solicitor General had done 6 moots the week before. The SG does 2 moots for each case. He had 3 arguments. He did 6 moots. His voice was parched. So before he got to the podium, he took a glass of water. It went down the wrong pipe. He choked. He could not breathe. He was literally gagging. But he recovered. And on this day, he was able to articulate pretty well that the court should fall back and say that this is a tax. We should construe it as a tax. That's the safest way to read it. Now, the big question, what's a limiting principle, right? If the government can make you buy insurance, can make you buy broccoli, can make you buy a gym membership, this question kept coming up over and over again. And the challenge in the lower courts was articulating the limiting principle. In the lower courts, Neil Cato said, listen, we have Lopez and Marsden. That's a gun-free school zone case, and that's the violence against women case. Okay? These are our limits. Verrilli said, no, no, no. The second I give the court a limiting principle, the second I give them any principle, I've given away too much. All these principles are too, quote, capacious. By giving them a principle, they can strike it down, saying, you know what, your principle's a line too far, we won't go that far. His strategy was to not give a principle at all. It might seem like a colossal mistake in hindsight, but this was intentional. If you read his briefs, there is no principle in there. He didn't want to answer the question of the limiting principle. In his mind, the way to win this case was to fall back from the taxing power. So when asked by the court, what is your limiting principle? Justice Alito asked him several times, what's your principle? He gave this long, rambling answer. He wasn't a fool. If you think of Muhammad Ali and Roboto, he didn't take the punches, because he knew he was going to fall back to this one. Paul Clement got up there and absolutely killed it. Killed it. One of those beautiful arguments you'll ever see at the Supreme Court. If you can, go listen to the audio, aspire to be that. None of us will be that. He was awesome. He killed it. They came back the next day, and they argued more about the Commerce Clause and the taxing power. Justice Scalia came in with the invariable broccoli question. Can the government make you buy broccoli? And again, Verrilli just totally changed the topic. He wasn't wanting to answer that question. Can they make you buy a GM vehicle? Wasn't going to answer the question. They came back on the 3rd day, and this was perhaps the most important thing that people didn't realize. This was about Medicaid. I didn't mention this before, but the Affordable Care Act, in addition to having an individual mandate, expanded Medicaid. It said every state, people were 133% of the poverty line are now covered by Medicaid. Okay. Who's going to pay for it? Right? It's expensive. So for the first few years, the federal government pays for it. What happens after that? After that, it's being paid for by the states. And many of the states oppose it, saying this will bankrupt us. We can't afford all these new enrollees. So they challenge it under the spending clause. And for those of you who say South Dakota versus Dole, that was the closest the court's ever come to saying it was a limit of spending power. But there's never been any kind of law struck down the spending power. The problem here, though, was the boldness of this program. Back in 2009, when the ACA was first being enacted, Arizona, Governor Jan Brewer, Tea Party governor, sent a letter to HHS and said, if we don't accept this new funding, what happens to our old funding? Health and Human Services wrote a letter back saying, if you don't accept this new funding, you lose everything. Your entire Medicaid program is defunded. That's staggering. That is what John Roberts called a gun to the head. There's no choice there. If you don't accept this new funding, you lose your entire Medicaid program and your state will go bankrupt immediately. The Solicitor General knew this argument was coming. But the government would not disclaim that power. He tried to work within the government and say, hey, listen, can we tell the court that if you don't accept the new funding, you keep the old funding? And they said no. HHS would not give up that authority. They wanted to retain the power to cut off all the old funding, which is staggering. So, Verrilli knew when the Supreme Court asked him, what about this Arizona letter? He couldn't answer the question. Breyer, Roberts, everyone was asking, what about this Arizona letter? Does the secretary have this power? And Verrilli kept saying, Your Honor, I can't comment on that. And then at one point, Breyer asked, just above your pay grade. And Verrilli says, well, Your Honor, I don't have the authority to do that. He's just a lawyer. He's not Secretary of Health and Human Services, not the president. Pope Clement got there, knocked it out, saying this is not constitutional. Okay. So we have three days of argument. Afterwards, everyone had their eyes on this guy, right? Justice Kennedy. What's he going to do? What's Kennedy going to do? Time magazine put him on the cover of their magazine. But really, all eyes should be on this guy. The steely blue eyes that they just dare, daydreamingly into, John Roberts. It was him, it was he, that would be the deciding vote. So we often talk about what happens inside the court. What happens outside the court, though, is perhaps the most important. The president and Roberts are actually fairly similar. Both Harvard Law graduates, they both have reached the highest pinnacle of their respective professions. But Roberts has a slightly different role. The president knew this. So 3 days after the conference, the case was argued Monday, Wednesday, Tuesday. The conference was held on Friday. This is when they voted on the law's constitutionality. The Monday after the conference, that very Monday, President Obama made a statement. He said, quote, it will be unprecedented for the court to strike down this law. He said the court should not do this. This was stunning for a former common law professor to tell the Supreme Court that they should not be striking this down. Now, he wasn't doubting judicial review. I mean, that was his intent. Rather, he was saying that in our separation of powers, with respect for a branch of government, you should not be doing this. So what happened next? The very next day, there was a judge in the Fifth Circuit Court of Appeals, Judge Jerry Smith, who had pulled a stunt. He told a DOJ lawyer, I want a letter from Attorney General Holder certifying that I have the power of judicial review. He actually demanded that the DOJ and the AG certify that courts retain this power. This was stunning. That afternoon, Obama doubled down, and he said again that the court should not strike this down. He said, not since the Lockman era has there been something like this. We should not be doing this. We have all three branches of our government clashing. We have the president, we have Congress criticizing the president, and now we have judges firing back at the White House. We have all three branches of our government clashing, and this is a terrible thing. And this could not have weighed well in the mind of John Roberts. He could not have appreciated this. He had to have seen this. So it all came back to Roberts. What's he going to do? Well, there were reports after the case was released that there were switch votes. I'll talk more about that in a few minutes. But you have an opinion. Decision day comes. How does Roberts vote? Complicated. He says a couple things. He first says that the mandate is unconstitutional under the Commerce Clause power. That is, Congress can't compel people under the Commerce and Necessary Proper Clause to buy insurance. But then he turned to the taxing power. And he said that the mandate is not a tax. It's not a tax. He says they didn't call it that. But, and here's the key, the safest, most reasonable way to read this to save its constitutionality is to read it as a tax. Even though it's actually a penalty, I will treat it as a tax. I will view it as a tax. It's a legal fiction. It's what my friend Ilya Shapiro calls a unicorn tax. It's never been seen before, will never be seen again. He said, I will view it as a tax. Think about this. The president said during the election, this is not going to be a tax. Roberts said, this is not a penalty. So what is it? We don't know. It's a tax. But the only way that Roberts can get to this point was through this one important representation. Generally speaking, if you fail to pay a tax, there's no other consequences. You just have to pay the tax. But if there's a failure to comply with a mandate, there might be some criminal penalties. If the law says you have to do something and you don't do it, it's a crime. One of the key things Verrilli did was to get a representation that if you do not pay the mandate, there are no other repercussions. The only way this can be viewed reasonably as a tax is if there's no other collateral consequences for failing to do it. The only consequence is you don't pay the tax, you might get assessed a fee or something, but there's no mandate. By saying there's no independent freestanding requirement to buy insurance, Verrilli paved the way to construing this as a tax. Once those planks were there, he was home free. I spoke with the lawyers who argued on behalf of the NFIB, and they said, we knew that if we lost this case, this is how we were going to lose. The court would say, there's no penalty, there's no collateral consequences, there's no penalty, so it's fine. The reason why I love this cartoon is because it's wrong. It says new crimes. I murdered 12 people, what even for? I didn't have my health insurance. But that's the key. Under the Obama administration's argument for the court, there was no crime, and that's how the law was saved. Of course we had the votes of the joint dissenters. The opinion, which was jointly authored by Kennedy, Scalia, Thomas, and Alito, although if you read it, it was really Tony and Nino who wrote most of it, they said this is all wrong, that the entire thing is unconstitutional, that all this time we had our eyes on Anthony Kennedy, how we would vote, he struck down the entire thing. He found the Medicaid expansion unconstitutional, he found the mandate unconstitutional. He was really sharp. We had the other opinion from Justice Clarence Thomas, who basically said most of the 20th century is unconstitutional. He said I would go back and strike down everything. That's his usual MO. But he was like, nah, it's fuck. Yeah. He wasn't down for that. Then we had the interesting votes. Joining the Chief Justice in finding that the Medicaid expansion was unconstitutional, that it was a proverbial gun to the head, were Breyer and Kagan. It's not abundantly clear why they did it. Perhaps they wanted to give some solace to the Chief Justice. He wasn't alone. Although during arguments, the questioning of both Breyer and Kagan were very critical of the government. The notion that you can withdraw previous funding for not accepting a new one seemed a little bit too much for this guy. Breyer actually wanted to do something with the APA, the Administrative Procedures Act, but I don't think that would have gotten enough votes. Ginsburg and Sotomayor, they dissented alone. They said, they were alone that the entire law is okay. And Justice Ginsburg very famously said at the end, I have a feeling that this opinion will be but a mere blip in our radar. It won't have much effect. She said that this opinion will be limited, that it only applies to mandates. We won't know much of this. But what happened outside the court is almost as interesting. There are no cameras in the courts. The only way to know what's going on is by reporters. So moments after the opinion was released, you had these people, runners, sneakers. They run outside the court with the opinions. They hand it to the reporter in the street. If you tried to read the opinion very quickly, and you only read the first few pages, you would think the law is upheld, or the law is struck down. Because if you read up to page 3 of the syllabus, it says, John Roberts finds for the court that it does not satisfy the Commerce Clause. You even had this reporter in the street, I can see her, I watched the video, she's holding the opinion with the first 3 pages flipped over, where it says Commerce Clause. How did you flip to page 4? She was seeing, oh, by the way, John Roberts throws a tax. But we have this beautiful image, which is preserved for posterity, you know, mandate struck down. How this will affect the election. CNN had already running their entire thing. But the most fascinating part is the president was watching CNN. He was sitting in the White House watching this news. He was, quote, crestfallen with this development. He didn't know what to do. Fox News followed in suit, saying, you know what? Struck down, unconstitutional. In fact, Megyn Kelly actually reads SCOTUS blog over her iPod live in the air, saying, wait a minute, hold on, guys, we got conflicting reports. Eventually, the president found out this law is upheld. And this is like the Dewey defeats Truman moment of the 21st century. It's remarkable. But in hindsight, I think the Solicitor General was largely vindicated. He was criticized roundly for his representation during the case, but he made a couple of key strategic decisions which most people didn't notice. Construing it as a tax the way he did, saying that there were no collateral consequences, not giving limiting principle. The decisions he made set up his ultimate victory. Now the gamble might not have paid off. Maybe John Roberts wouldn't have been affected by this little bit of garbage, but we know it did. What about the chief? In some respects, I have a respect for what Roberts did. He had a serious understanding, a profound understanding of where he sat within our constitutional order. What was his role among all the other branches of government? And he was willing to take a hit. He knew that he would bear a serious cross for this. He knew that he would be excoriated by conservatives. He would not be invited to the next Federal Society banquet. I mean, you know, he will not be loved. I mean, there are many people on the right who just are pissed at him. That, we elected our president, we got our Chief Justice nominated, and this is what we get. This is going to be another John Paul Stevens or another, Harry Blackman. We don't know. No relation, by the way. We even had Glenn Beck saying that, John Roberts is a coward. He sold all these T-shirts. It's remarkable. He had these T-shirts out within a day. So then we go back to the politics. Throughout the entire time people kept saying the only way to get rid of this law is to strike it down. The only way to get rid of this law is to strike it down. Well, we had an election. 3 months after the case, or 4 months after the case was decided, we had an election where the very issue could be resolved. If the political branches wanted to get rid of this law, they could. If all the politics said we want to repeal this law, no problem. It doesn't go into effect until 2014. So this guy, what's his name? Romney something, I forgot already. He gave a press conference moments after the courts upheld the law, saying we need to repeal and replace Obamacare. Of course, the only problem is he is the grandfather of Obamacare. He created his own state. Obama would always make fun of him at the debate, saying that I got Obamacare from you. This was a great idea, Mitt. Thanks so much. He was the worst possible candidate to run against him. In fact, James Carville and Paul Begala and Rahm Emanuel said, who do you have to run against Obama on healthcare? That'd be it. He was the worst possible candidate on this issue. He was done. And with Romney's electoral defeat by a large margin, the issue of health insurance was largely dead. The mandate will go into effect. The Republicans have the House, they don't have the Senate, they're not going to repeal it. Even if there's a Republican in 2016 who wants to repeal it, it'll already be in effect. And it's almost impossible to unentrench this, if I can use that made-up word, to kind of take back this law that's been enacted. So what happens now? We go forward to 2013. We got another oath. In fact, this is the third of 4. President Obama shares an honor with President Roosevelt, among others, as being the only president to take 4 oaths of office. Roosevelt because he was elected 4 times, Obama because scheduling conflicts. The first time he couldn't get the oath right and did it again. The second time, the inauguration, January 20th, fell on a Sunday, so they had one fake one in the White House, and then another one the next day in front of the millions of people in Washington, D.C. But here we have Obama, shaking hands with John Roberts. And this is, I think, probably the first time the two had met since the healthcare decision. I would love to hear what they were saying. I'd be like, you're welcome, or thanks, buddy, or something like that. But we saw the issue of health insurance. The bitter irony, though, of the Roberts opinion is that the only reason he was able to uphold the law as a tax was because it wasn't very high. He said that this penalty, this mandate, is not punitive, it's not high enough. But there's a problem with that. The only way that the penalty will be effective is if it's high. If the penalty is still low, people will choose to pay the penalty rather than buy insurance, which defeats the entire purpose. Roberts' opinion doomed the Obamacare law into its own demise. For someone young and healthy like me and a lot of people in this room, it's cheaper for you just to pay the penalty to buy insurance. This is what's going to kill the law, no pun intended. People are not going to buy insurance as well. Costs are skyrocketing. Premiums, especially in California, have gone up significantly. This is not an accident. This is what's going to happen. Costs will go up. Employers will cover less people. They'll convert more people to part-time. And less people have insurance. So at the beginning when I said, if the president wants to have this as his legacy, I say go ahead. I think in years to come, this will not be viewed the same way we view Social Security or Medicaid or Medicare. This will be viewed as a rush compromise that should not have been passed. Maybe I'll be wrong. Maybe I'll be wrong. But it's not looking good already. Most of the states haven't met the deadlines for the exchanges. The president's relaxing a lot of the deadlines. It's going to be a very uphill battle to make this law. With massive opposition, it's going to be a tough haul. But also we have this interesting thing about the Constitution. We have this Tea Party, this popular group, which rededicate themselves, however conveniently, to the Constitution. Where did these people go? I mean, they just kind of disappeared. My feeling is that this is a latent force that, with the right law, can be reignited. Maybe it'll be a gun control law, or who knows what it'll be. But this current in our constitutional culture is still there. They didn't just vanish. And I think when you have the next kind of overreach of federal power, these might come back. And what about these two? There was a very touching moment at the inauguration where President Obama had just left the podium. He was walking back with his family. And he said, you know what, hold on 1 second. I want to take another look at this. He turned around and looked at the millions of people. It's like, I'm not going to see this again. And it's a touching moment. I mean, he's term limited. He's out, unless his wife runs for president. But he's term limited. But this guy, he's not. Roberts is looking forward. He knows, I'm going to be here for a long time. I got to be 7, 8 inaugurations ago, depending how long I live. The ACA case was a blip. It didn't fit anywhere else. This is not like affirmative action or abortion or Voting Rights Act, where the Republicans have kind of been working on these things for decades. The ACA came out of nowhere. And it won't happen again. There will never be a mandate, not because of the court's opinion, because Congress isn't stupid. They said, holy crap, this mandate, this entire thing, they're not going to do this again. But there are other things that the court will have. This term, we have affirmative action. We have voting rights. We're going to probably have there's probably some sort of contraceptive mandate case next year or two. These issues are coming back to the court. And Roberts knows that we need to maintain the court's legitimacy. Let's not kill this law that doesn't fit into the bigger arc of things we're working on. The Medicaid issue, though, did, because that's an issue of federalism. The structural protection of the Constitution, in my mind, are much more important than any individual rights. That is a key, and that's why the Medicaid opinion was even more important. And ultimately, we have the Constitution. What does it mean? What does the NFIB case mean for a Constitution going forward? Are we going to have limits on purchase mandates or limits on federal spending? What does it mean for other Medicaid programs? We don't know. But what makes this case so important is just it was unprecedented. It came out of nowhere. It happened so quickly. And it's gone before we know it. And I'm just stunned by how quickly this constitutional change happens. You know, we speak of change in terms of decades, you know, movements, the Warren Court, the Burger Court. This happened in months. Once you have a major party, the Republican Party, get behind this constitutional movement, it's off to the races. And figuring out how to tap into this energy holds so much potential for the future of constitutional governments. Thank you very much for your time. I love this conversation, so please fire away questions. I love talking about this stuff. Yes, sir.
Yeah, thank you very much for coming.
Thank you.
Very much enjoyed the walk down memory lane. I just had a couple of quick questions, or a couple of quick points in the question, I guess. So you mentioned that Obama, of course, had a filibuster-proof majority after he was elected, and that's incorrect. Of course, it took them, the Republican Party, driving out Arlen Specter in order for him to get there.
And Al Franken.
With the delay election. So that, just to, and for the sake of accuracy. I also would encourage you to recognize in this kind of discussion that the Medicare and Medicaid, passed with the potential for them to have been filibustered. And it's interesting that another unprecedented part of this is the first, big policy change like this that was subject to a filibuster, especially right after an election, which is another interesting, I think, unprecedented aspect of the law. And then to the point of no big legislation being passed on a party line vote, I would argue with you, I guess, the 93 Omnibus Balanced Budget Act was passed early in the Clinton administration and eventually led to the balanced budgets that we enjoyed in the late 90s, which was all done with only Democratic votes as a counterexample. But I guess the real question I have, and thank you for just allowing me to rattle those off, is related to your point that this challenge was was born in Washington. And I wonder, do you think the results would have been different if there had been more patience instead of rushing to make this challenge, more patience to allow people to discuss back and forth, perhaps in a less emotional way, the law, and there's definitely negative and positive consequences from it. But do you think that kind of litigation strategy coming from a centralized place in Washington is the best way to go forward with these kind of challenges in the future?
Okay, so thank you for the question. You're absolutely right. I mean, the 61st vote came after all. I think actually the Al Franken election was disputed in Minnesota. It happened like in June. And I remember reading somewhere that it was effective right after Al Franken's election settled, Obama says we're going for this. So they did not have the filibuster proof in January. But to go to your question, I think this is a terrible way to make law, and a terrible way to challenge law. Although I was present when this challenge was born, I didn't quite contribute because I didn't think it was necessarily a good idea. The initial law was passed over a lot of opposition, but not just among Republicans, but among Democrats. If you remember back, most Democrats wanted single payer. That's what they wanted. And they wanted a public option at the minimum. This was some sort of bizarre compromise bill that no one was excited about. And when you have a law that really no one's excited about, you're not going to have that kind of popular support for it. I think it was Larry Summers and Borzak and various people in the White House told Obama, you should not be doing this now, we should focus on the economy. If you remember 2009, we had TARP, we had all the bailouts, all this stuff was kind of trickling. And this wasn't on the forefront of Americans' attentions. And the president had the idea that if we don't do this now, we'll never do it. And perhaps in hindsight, he was right. Perhaps in hindsight, if he didn't do it back in of 2009. I mean, look at what happened in 2010, 11, 12. It wouldn't have happened. So that raises the interesting question. Is it even possible to pass broad landmark legislation in today's gridlock culture? You know, the same way that Johnson was able to get Republicans and Democrats to vote for the Civil Rights Act, for example, or FDR got Republicans to vote for Social Security, or even how the EDA was passed with George H.W. Bush with both houses. Can that even be done today? Would Mitch McConnell ever support any healthcare law passed by the president? And I think that's probably no. So if the answer to that question is no, what does that do to the government's ability to solve these kind of national problems? Can they even pass these kinds of laws? And the answer to that question might also be nothing. And that's slightly disturbing. Putting aside the policy where we think this law is a good idea, the inability of the government to kind of react to changes is dangerous. Perhaps one buy-in is to try to, like you said, kind of make this debate more spread out and have the heartland of America talking about the needs of healthcare, rather than just saying, you know what, Al Franken's in, we're going for this, we're going for two, we're just going to push this in. And I think that's a dangerous way of governing. And the president, you know, to his credit, he was able to push it through, but the cost of pushing it through might persevere long, long after he's out of office. I think we'll have serious problems. Yes, sir.
I always have a hard time understanding people saying that this bill or this approach to solving the healthcare crisis wasn't debated long enough or wasn't discussed generally by the populace. President Obama ran on this issue.
He didn't actually. In
2008.
Fact, in fact, Hillary Clinton ran this issue.
That's right. It was discussed a lot during the Democratic primaries by those two candidates, and both of them supported changes to our existing health care law because we'd seen such dramatic rise in premiums before Obamacare came into effect. We saw an incredible rise in premiums. I certainly did, and it was a very strong issue at that time. For you to characterize the opposition to Obamacare as 50-50 or a big huge amount of people out in the country as opposing Obamacare undermines your credibility, because it was clear, when polls were taken, that a good third of the opposition was made up of people who wanted a stronger single-payer type health care change. And the number of people who were against Obamacare or for the status quo, against any change, was more in the 1/3 area rather than 50%. But I hear that all the time. It's a trope of the right wing that half the country or more was against Obamacare. To me, that undermines your credibility when you simply repeat that. Similarly, when you say that the Medicaid proposal offered as a bone to the states that the federal government would pay for Medicaid for the next 2 or 3 years, and after that it was the responsibility of the state. 10% of it was the responsibility of the state. That was only after several more years. For you to say that the federal government was holding out this promise, we'll pay for it and then it's all on you, is completely wrong.
Okay, a couple points in response. Let's go back to 2008. There was a candidate who wanted to have an initial mandate. Her name was Hillary Clinton. Barack Obama attacked Clinton nonstop for the mandate, saying we should not be forcing people to buy health insurance. He said that very clearly. If you go back, the entire debate, he kept saying that we should not be forcing people to purchase health insurance. It's wrong. Obama's was based on a public option. So to say just broadly healthcare reform, sure, people want to reform healthcare. I agree with that. But the manner in which they reformed it was not what was happened. This was kind of this cobbled compromise that no one wanted. Some Democrats wanted single payer, some people wanted a public option, some people wanted health savings accounts, people wanted tax credits. There were various ways to have a debate, but he said, we're going to do it this way or the highway. To the second point.
The compromise that was adopted was obviously not single payer. It was something that included a mandate at the behest of the drug companies that would never sign on to any sort of change without that sort of protection. And it was adopting the exact language implemented in Massachusetts and supported by the Heritage Foundation and by Senator McCain. Two major things that happened before Obamacare was proposed that you didn't mention. You just said, nothing happened, then all of a sudden, Obama came up with this draconian change that came out of nowhere. Well, it didn't come out of nowhere.
I have an entire chapter in my book about heritage supporting this, as well as the fact that up until about 2011, both Newt Gingrich and Mitt Romney supported it. I talk about that at great length.
Okay, so Obama didn't say this way or the highway, or perhaps he did, but what he chose as this way was a compromise that had he had the bulletproof majority in the Congress that you said he had, he could have simply, chosen a path that would have made all of the progressive, backers of him very happy. But he didn't. He chose something that was clearly a compromise, partly to get the drug companies on board. But he recognized that there was going to be opposition to it. I just don't see the whole process as one where he drove this, horrible, dramatic change at the,
And I agree, there's a large amount, and I talk about this at length, there's a large amount of hypocrisy on the right. So for the background, those of you who don't know, in 1988, a guy named Stuart Butler at the Heritage Foundation said that a way to lower healthcare costs was something called a mandate. If we force people to buy insurance, then they'll have it, and they won't cost shift. They won't go to the hospital and go to the ER and cost shift. And this was actually the vanguard of the Republican Party for most of the 90s. In fact, when Hillary Clinton was doing her healthcare reform in the early 90s, the opposition from Newt Gingrich was something called the HEART Act. It was like the health, something I forget what it says, with the HEART Act. Supporting that was actually Orrin Hatch and Chuck Grassley. And in that law was actually a mandate saying that we want to force people to have insurance. That law was percolated throughout conservative circles, and when Mitt Romney was governor of Massachusetts, he actually imposed it, along with Ted Kennedy. That was their solution. Very conveniently, and I think you're exactly right, opposition to Romney Care, or as it was called, bloomed quickly. The second the president said, I'm going to do this, it was opposed to. Now, I agree, it was purely political, it was seizing the moment. But the fact is, and I think public polling data shows that, the mandate was unpopular. 49% of Congress voted against it. And I think you're right, I think people wanted change. But the manner which was done by the time this got to the House, 210 to 219 to 210, I mean, the votes are there, these are people representing. In fact, the day before the House vote, Obama gave a speech at the Capitol Center Visitor Center where he's told the people, listen, some of you are going to lose your seats because of this. I know you're going to lose your seats because of this. Do the right thing. Also profiles encourage type of address. Like, I know you're going to lose your majority. He knew Speaker Pelosi was going to be majority leader, or minority Pelosi. He knew that, but he wanted to do it anyway. And to the extent that the Republican opposition was unprincipled, and I don't think it was, I think it was purely political, and I'll agree with you entirely, we still had the fact where a majority of people were opposing this. And where do you go from here? And that's the question. Sir, I think your hand was up.
Yeah, my observation is just going to be that I would agree that it was a compromise, but it was a compromise that nobody wanted. The left didn't want it, and the right didn't want it.
Yeah.
And I think one of the main issues, as I see it, with the bill was Nancy Pelosi's position. We'll know what's in the bill when we pass it. I think that's what a lot of people have an issue with. There was no transparency.
Yeah, and it's kind of ironic. Obama frequently criticized Hillary Clinton during the debates in 2008, saying, you drafted this behind closed doors, you should not be doing this, which is exactly what happened again. The Democrats gave the Republicans a 2,700-page bill, I think, 10 days before it was to be voted on. I mean, no one had time to read it. No one could have possibly read it. And the rulemakings funds forth, and we know now, I think there have been almost 9,000 pages of rulemakings made from it. The law was just passed in a way that we had to get it done now. Obama said we need to get this done before the end of the year, and that was the deadline. To the extent that that was rushed, or that he was pushing it through, you can argue that he wanted to get done then. And in fact, even after Scott Brown's election, people in the White House think, maybe we shouldn't do this, maybe we should stop. And the president said, no, let's move forward. Let's try to negotiate and reconcile this bill. Nathan.
I'm intrigued by your insistence that the struggle between the branches and the sort of political machinations in the making of the law are somehow a problem. It strikes me as the system working exactly the way James Madison expected it to work, which is there's going to be lots of discord. It's going to be rancorous. It's going to get ugly. Let's channel it some way. And a wild card, which I think you did a really lovely job of highlighting, is how is the court going to respond when it gets asked to decide political questions effectively? So is it, you talk a little bit about sort of the long-term consequences of this. I wonder if the consequences are relatively modest in terms of politics, and in terms of policy, you know, who knows? There's no guarantee the system is going to create good policy. But what it can do is create a situation where nobody really gets what they really want most of the time, but don't kill each other.
Right. I mean, I think this is a very kind of Madisonian conflict in that sense. It's a fair point. I like good government. I like people coming together and reaching consensus and passing laws that solve problems. I think that's generally a good thing. I don't know. I like to think that's what government wants to do. To the extent that government simply just gridlocked and passing law on party line basis that everyone hates, it creates a lot of what's called externalities or transaction costs, which distract us from solving what's actually at issue. I mean, I agree. Healthcare is a problem. It's been debated in this country for 2 decades and 5 decades and 7 decades. Teddy Roosevelt wanted to have a national healthcare system. Richard Nixon wanted to have a national health system. This is something we've had for much of the 20th century. And I fear that by doing it in this manner, we've kind of burned the chance to fix this. I mean, we're going to be stuck with Obamacare, good or bad, for the foreseeable future. And working at the kinks and trying to figure it out, and whether costs will go up, and people kick off insurance plans, we don't know. And maybe if we could have had a more, Madisonian dialogue rather than Madisonian conflict, this could have been better. But in our gridlock Washington, I don't know. Yes, sir. Oh, sir, I don't know. You have to ask a question.
Do you sense any capability for getting back? Because it seems to me also we had only Democrats voting for this. We also had only Republicans voting against it. And we hear our purpose as Republicans is to win the next election. To the hell with what happens until that. Mm-hmm. And we see that before and after Obamacare. What do you think it's just going to take another generation until you get 75% Republicans to get a rational government?
I don't know, and I don't think this exercise makes things better. I think one of the lessons that we can draw from the ACA case is that when something is very unpopular to most Republicans, they can group together, they can block, and they can all come together and unite this with force. Even if you go back and look historically at various laws, there was at least some Republicans that broke across the aisle. Here, there were none.
Right, after the Obama election.
And I can't see this.
Or after Gingrich turnover.
I'm not particularly hopeful. I don't have a crystal ball. I don't know. But if this is a trend, I mean, I can't imagine President Obama passing any kind of significant legislation in his second term, because this will happen if he tries to pass some sort of gun control law or climate change or immigration.
Rand Paul would be able to pass laws against a 42% Senate, Democratic Senate?
Well, it would have to be the nature of the law. I mean, perhaps if there's something that's some sort of bipartisan buy-in, if you get the various groups of 8 or groups of 12, all these groups that come together, maybe there's a way to get past the filibuster. I mean, the lingering question is the filibuster reform. I mean, we've been talking about this nuclear option for what seems like forever, how to get around the 60-vote requirement. I don't know if any of the senators, probably Reid has the balls to do it, but it's there. And the Madisonian gridlock, was a filibuster even constitutional? People argue it's not even constitutional. If the 60-vote block is gone, government can be a lot easier.
65 and 70?
No, to 50 or 51.
Why would any lower party?
Well, the point of the nuclear, I mean, this thing called the nuclear option, which has been bandied about, is that the majority party wouldn't need the minority party to vote for it. You can pass as a rule change which requires a simple majority.
At any time, too.
Yeah, at any time. So that judges, you'll need a cloture for judges. You'll need a 60 vote for passing laws. But the problem is, if they do that and they lose the Senate the next time around, oh boy. I mean, to the victors go the spoils. They're going to just run it through the other way. So that's why it's been this like détente. It's been like a détente. It's like mutually assured destruction for the filibuster. Yes, sir, in fact.
So just going back to the Madisonian dynamics, we've got precedent for vicious political infighting and blocking and lack of movement and various forms of compromise to get past that. From your perspective, what precedent do we have for this kind of opaque law passing where nobody knows what's in the law?
Chevron? I don't know. The way our modern administrative state works is that it's not necessary to know it's a societal law to pass it.
Right.
Most of the laws say this agency will make this rulemaking and there's certain guidelines and principles. And so I think Mitch McConnell had a picture a few weeks ago, 7 feet high, of all the rulemakings from Obama. I think it was like 12,000 pages and some sort of large number. But I think the crux of Pelosi's comment, you need to pass law to define what's inside of it, goes beyond the Administrative Act. This is saying, listen, we're going to be passing a law which none of you have time to read, and none of you have time to debate to figure out what's going to happen, but we need to do this now, so don't worry about it. And I think that's dangerous. I don't like the idea that the people I vote for in office are casting votes for laws which I know no one's considered all the implications of. And you're absolutely right. The reason why the mandate was put in is because the insurance companies demanded it. In fact, there was one episode where the head of the insurance lobby, her name was Karen something, I can't remember her last name, flew to Chicago headquarters, where Obama's headquarters were, and said, listen, if you want our support, you got to put a mandate in here. They basically said, this is our terms. They ultimately ended up not supporting it, neither here nor there, but the insurance company loves this. It creates millions of new customers. Why wouldn't anyone want? I mean, if the broccoli industry could have a mandate to make people buy broccoli, they'd love that. But you have a lot of capture from industry, you have a lot of people drafting laws behind closed doors to lobbyists. I don't like it. And this is something where I think we're going to get burned because just one random provision that people don't even know about. There's actually a provision somewhere buried in Obamacare that the NRA inserted that said that Congress can't pass laws that would allow doctors to ask if people have guns in the home. You know, Florida and other states have actually passed laws saying that a doctor can't inquire about firearm ownership. The NRA inserted that provision to the ACA. Who the hell knew? No one. I found this out like 2 months ago. There's lots of stuff in there. We'll just have to keep waiting to find out. 2,700 pages is a long time. A book's like 300. That's like 9 times my book and probably a lot more interesting. Okay. Yes, sir, Derek.
So, stepping back a little bit, you've written now a book with a great deal of detail and sort of presented very interestingly about the Supreme Court challenge to Obamacare. I'm wondering what you think overall, how you assess that challenge from the standpoint of what you call popular constitutionalism or maybe sort of conservative popular constitutionalism. Was this in any way something as a model for future litigation and future sort of activism on behalf of sort of constitutionalism, or perhaps as something to sort of actually more or less be avoided in some respects?
So I think it's both something we should model and something we should avoid. The only reason this could have come about is because there was such wide opposition on the right. Once, you know, when Randy Barnett and others, and Randy wrote the 4-ton book, so full disclosure, when Randy and others were kind of creating these ideas in the blogs in early 2009, people weren't really taking it seriously, and they were being ignored. But you had the Tea Party, this massive group that sprung out of nowhere that said, you know what, we should not be forced to eat broccoli. We should accept this argument. And along the same time, prominent Republicans started saying, you know what, let's put this into the congressional record. Let's read Randy Barnett's report into the record, right? All of this kind of discussion and utterance kind of reinforced the idea that, yeah, maybe this argument's not stupid. Most academics on the left, with a few exceptions, ignored it and said, no, this is stupid. We're not going to waste our time with this. By not taking this seriously, by ignoring this constitutionalist argument, they gave Barnett and others a spotlight, that they can kind of advance this on their own. And I think that kind of the hubris of saying, you know, this is silly, was short-sighted. I think going forward, if you ever see some sort of constitutionalist argument that came out of nowhere, take it seriously. Case in point, DOMA, the federalism argument, right? Where did that come from? That the Defense of Marriage Act violates principles of federalism? That was like invented like not recently, but it's gained so much attention in recent times that we should be taking it seriously whether you oppose it or against it. So to the extent that there's future laws being passed and that there's a constitutional angle to it, you know, in our system we always have this strong sense of the Constitution. So the abolitionists, Lysander Spooner, said, you know what, slavery must be unconstitutional because the word slavery is not in the Constitution. Susan B. Anthony read the 14th Amendment, which doesn't use the word male, it says it uses person, to say we have the right to vote. Throughout our history, people have looked to the Constitution as kind of this higher power. And when you have these prominent groups backed by political parties that are looking to the Constitution for this higher power, you're off to the races. And that's what enabled this challenge to go from nowhere to somewhere in like 3 months flat. It just took off. So to the extent this can be replicated, that you have this kind of opposition to these laws based on some sort of a cultural constitutional movement, people should be very concerned about that, or we should be very exploiting of that, either way. And I think it's To assess the challenge as a whole, though, although it didn't work, although the law was ultimately upheld, I think what it did was it shifted our constitutional culture. The notion that the New Deal hasn't settled everything is what Larry Solms called our constitutional gestalt. That is, the way we look at the New Deal settlement has been changed. You know what? What we've done before, what's come before, Lopez, Raich, Morrison, Wickard, those are fine. But if you want to go farther than those cases, you got to justify it. So if you're the government, you want to step beyond Raich and Lopez and Wickard, you're going to have to justify it. Look how Verrilli argued the case. He wasn't saying, Your Honor, this is Raich and Lopez. He was saying, Your Honor, here's where we're justifying this, because there's this national problem. We have cost shifting, we have debt spirals, we have these other things. You need to justify it. So I think going forward, things are in play that weren't in play before. That might be the most enduring legacy. Congress won't impose any more purchase mandates, that's out of the question. But they will try and massage things to let these ideas germinate and kind of come together. Now, I don't know if we'll ever see anything quite the magnitude of the ACA case. This was indeed unprecedented. I don't use that title lightly because it was such an important case. But I think popular constitutionalism has taken a serious plus in this case, especially for the right, because it's usually a liberal concept. Other questions? Yes, sir, come back.
Where do you see Obamacare in 20 years' time?
Oh, God, I don't know. Hope I'm still alive. I'm sure I'll be on the waiting list somewhere. I don't know. I don't know. I'm not an actuarial. I don't know. What I do know, though. No, I mean, what I do know, though, is that the very mandate that's meant to make by health insurance won't be high enough. If Congress tries to raise the mandate, assuming they get the votes, which they won't, but assuming they have the votes to raise the mandate, it'll be unconstitutional. Why? Robert says opinion. The mandate only works as a penalty so long as it's not so high to be coercive. The second it's coercive and makes people buy it, it's unconstitutional. So we're stuck with an ineffectively low mandate that won't work. Health insurance costs will have to go up and people will choose not to buy insurance. And I don't know, we'll come back here in 2020 and see what the question is.
That's not the only solution, though. I mean, part of the reason that people get away with not buying health insurance is they are pretty well aware that they can go to hospital and get free emergency care. It's not good care, certainly.
Right.
It'll keep them alive in most cases. I don't think the insurance companies will keep offering that.
Well, there's EMTALA. I mean, the reason why we had this issue in the first place was the Emergency Medical Treatment and Something Act, which passed by Reagan, which said if you go to an emergency room, you can't be turned away. They have to treat you. And that was an unfunded mandate, because that shifted the cost of the treatment to the hospital, but then shifted to the other patients who had insurance, which created, I mean, it's one begets another.
So if you start to pull that right or that protection away, it's not a tax, it's not a penalty, it's much easier to change that and start to, push people to get the health insurance that we all wanted to have.
Yeah, I think the answer to your question is probably implicit in your answer. Is we'll probably have single payer at some point. I think that the ACA is just a pit stop on the road to single payer.
That's right.
It's invariable because what will happen is they'll make a government option because costs will keep going up. They'll say, oh, we need a government option to compete with the private sector. And then once there's a government option, they can price the other people out of business, and we'll have something approaching maybe Canada or the UK. I don't know when, about 20 years, 30, I have no idea. Sir?
Popular constitutionalism. That means that the Supreme Court looks at the Gallup polls to find out what most of the American public thinks is constitutional and passes as though on that. Give me a definition.
Oh, there's no good definition. It's important. It's this kind of, it's an academic concept. It's not an actual construct, but it's a notion that the people can affect the meaning of the Constitution, that by channeling some sort of higher power of what the Constitution means and aspirations, that they can actually affect it, and the court should take notice. I mean, the former dean of this law school, Larry Kramer, wrote a book called,
The People Themselves.
The People Themselves, yeah, which said that the courts are never too far away from what the people want. They don't read Gallup polls, but they kind of get a sense of what the people want. Also, Barry Friedman and NYU has written a book called The Will of the People, which looks also how the people can impact higher constitutions. I think we're out of time.
Yeah,
but you're welcome to come up and chat.
And he's got some other things to attend to on campus, so I want to give him a chance to break.
All right, thank you so much. Thank you very much.
Thank you very much.
Thank you.
Can I help you shepherd into your?
No, I can walk. I'm right across. So
Okay.
like maybe like tonight, like later, like maybe like at I guess what's that? When are you on campus still?
I'm going to be here.
Do you have my cell phone? What are you doing for dinner? Thank you so much.
Probably at 6-ish.
Well, I'll tell you what. When you make your dinner plans, do you have my cell phone number?
I don't think I do. I was gonna just shoot you mine, but via email.
Yeah, that's fine. But just give me a message. The thing about having a reception from 5 to 6,
Yeah.
and the probably for dinner after that. So I might, but the dinner probably later. So I might be able to hang out with you guys around for a bit. I'm not flying back to the Red Hawks, so I can tell you that.
Or do dinner later.
I think so, but I don't know what time. So I mean, but I'd like to go hang out with you guys as well.
Yeah. Well, I'll shoot you an email. You know, we're